Download our complimentary guidebooks, checklists, and other useful financial resources at savantwealth.com/guides.
Welcome to today's Savant Live webinar. Thank you so much for joining us. Today we will be discussing Estate Planning 101. If you are new to estate planning and don't know where to begin, this is a great first step. We hope to share some practical strategies and to help you understand the terms that are often used in estate planning. My name is Alaina Davalos, and I'm a wealth transfer advisor in our Atlanta office. Joining me today is Dominic Parillo. Welcome, Dom.
Hi, Alaina. Thanks for having me again. It's good to be here. Like Alaina mentioned, my name's Dom Parillo, and I'm joining you from our Manassas, Virginia office. And I work with Alaina on our wealth transfer team at Savant, which is really our internal estate planning team. And Alaina and I and other team members of Savant have done many webinars, and we found that estate planning is a very interesting topic to many of our viewers. And it's good to have a firm grasp on the basics and foundational concepts of what an estate plan is, why it's important. So we're really excited to get started today and share with you some great information. All right, Estate Planning 101. Let's dive in. So from an agenda standpoint, we want to introduce everybody to just broad definitionally, what is estate planning? Why is it important? Of course, we're going to cover key estate planning documents that we think everybody needs or should consider executing with their attorney. We're going to cover how property passes at death, because the titling of assets and whether or not there's a beneficiary designation will really determine how that asset passes. And that's important because you want to make sure things are coordinated with your overall estate plan. We'll give you some tips and tricks on how to communicate your plan to your loved ones and future heirs. A little bit on the probate process, what's involved in settling a decedent's estate. And then finally, we'll talk a little bit about estate taxes and other important information that's often overlooked when it comes to income tax filings for trusts and estates as well. And then again, at the end, if we have questions, we'll do a little Q&A. All right. What is estate planning? Alaina, I always like to start this conversation with a little bit of trivia. Do you know what Abraham Lincoln and Jimi Hendrix had in common?
You know, Dom, I don't know what they have in common. Can you tell me?
I don't think you've ever heard this before, but both Abe and Jimmy did not have written estate plans when they passed away. And it's just a little reminder to everyone that's listening and viewing today that we all are very busy people. And no matter how sophisticated you are, or how famous you are, everybody needs an estate plan, because nobody gets out of life alive, unfortunately. You just don't know when your time will come. So from a definitional standpoint, estate planning is really the process of determining who's going to receive your assets, the stuff that you own, and who's going to be in charge of handling the distribution of your property, financial assets, when you pass away, and also when you're incapacitated. And really the goal for many people when they design their estate plan is making sure that the assets, the things that they own, are distributed in accordance with their wishes while minimizing tax exposure, legal fees, complexities in administering the estate, and providing important protection structures for their loved ones. Minor children, beneficiaries who aren't good at handling money, those sorts of individuals sometimes need a little bit of protection. And believe it or not, everyone has a default estate plan, even if you haven't formally executed written estate planning documents. Because if you pass away without a will or a trust, the state that you live in will determine how your assets are distributed based on state intestacy statutes. And that statutory distribution scheme might not accomplish what you have in mind, especially if you're charitably inclined you have a blended family, which is becoming very common, or you want to provide protections for people. Those things just won't be accomplished if you don't have a written estate plan. Okay. So on our next slide, who needs an estate plan? Everyone. And often we get asked, after I create my estate plan, how often should I review my estate plan? I know our slide says annually. Practically speaking, most people review their estate plan every 3 to 5 years, but Alaina and I agree that if you have a major life event, a significant change in your net worth, death of a spouse or other loved one, children that reach adulthood, a divorce. I mean, those are key life events where you'd want to probably review your estate plan with your attorney or financial advisor, just to see if an update might be warranted. Of course, state laws can change. Estate tax exemptions can change income tax rules. So there's a lot of reasons why you want to review your estate plan regularly. And then next section, again, was going to be covering just the key documents that everybody needs, the basic building blocks of a good foundational estate plan. And I think most everyone watching today is going to know a few of these things. We want to give everybody an introduction into these documents, what they are. So you have power of attorney documents for both property and healthcare, living wills and advanced medical directives. This is the one I think most people are going to be familiar with, your last will and testament. I think that's the quintessential document that most people think of when they think of estate planning. And then finally, revocable living trust. So we're going to step through these in turn. And I think that it makes sense to talk about power of attorney documents and advanced directives first, because when you think about the spectrum of when these documents and the timing of when they'll be needed to be used, dealing with incapacity during your lifetime is when your power of attorney documents will be most used, most valuable. So on the next slide, we'll talk a little bit about power of attorney for property, healthcare, and advanced directive documents. So why are these important? Well, if you are unable to make decisions for yourself because you become ill, there's an accident, you have diminished mental capacity, and you become legally incapacitated, you will not be able to make financial and healthcare decisions for yourself. And if you don't have power of attorney for property and healthcare documents in place, a court is going to have to appoint a guardian or conservator for you to make those decisions. And that person that the court appoints might not be the person that you would choose. And whenever there's court involvement in any issue or transaction, there's going to be a lot of additional costs. It can be embarrassing for that person that ultimately has to have that guardianship or conservator appointed. And also, that it's a lot of additional hassle work, supervision that person would need to get to transact on your behalf and make decisions. So power of attorney documents can remove the courts from situations where you're incapacitated. And there's going to be 2 key documents that you should consider putting in place, or if you're not, make sure that you have these, if you have other estate planning documents. First one, a power of attorney for property, is a document that allows you, the principal, that's the person who creates the document, to appoint an agent who can act on your behalf to make financial decisions if you're unable to do so. And generally that agent can do everything that you can do on your own accord, if you were able to. Many states have superpowers, we'll call them, that have to be outlined specifically in a document when it comes to changing an estate plan, changing beneficiaries, gifting assets, that sort of thing. So when you work with your attorney, just make sure that you have the right powers in the document and give that authority if you anticipate that your agent will need to do some of those, we'll call them extra special things. And again, that power of attorney document will last up until you pass away. When you pass away, then your estate and your assets, they're going to be administered by your executor or your trustee or passed in other ways, as Alaina will discuss in a few moments. Okay, so the power of attorney for property makes financial decisions. Your healthcare power of attorney agent is going to make medical and healthcare decisions on your behalf. In addition to having that person named in your healthcare power of attorney document, you also should consider creating either a living will or advanced medical directive. Sometimes, depending on the state you live in, it's one single document. But basically, that advanced directive or living will declaration will provide your end of life instructions and desires to your healthcare providers, whether or not you want artificial nutrition or hydration withdrawn or administered, right? That's a very difficult decision that a family member appointed as agent would have to make. So you can pre-make those decisions, and then that's a binding instruction basically on your physician's healthcare provider and family. So that's a really important document. On the next slide, we have a couple of tips and tricks and considerations for you as you review your documents or you think about creating them with your attorney. A couple really important bullet points here, but the one that really stands out to me is naming multiple successor agents in the document itself. Because again, the point of these power of attorney documents is to avoid the need for a court-appointed guardian or conservator. So if the person you name, let's just say you name your spouse, if that person predeceases you, or you're both in a nursing home, right, or both incapacitated, then, now your, family's in court trying to get appointed because you had no one named after that spouse who's now also incapacitated. So, if you can, name at least one, ideally two other people. And it's something that you're going to be probably reviewing from time to time because the people you name in your document also get older, right? So you want to review that, make sure the people you name are still the right people, right? Sometimes you might think about naming adult children when they're ready, when they're financially mature. So that's a big one. Let's see. Another thing is that when that document becomes effective, right? So we talked about how power of attorney documents allow the agent to act during your lifetime, but when that agent can start acting on your behalf is really determined on what the document says. So from a financial planning, advising standpoint, we often suggest that our clients create documents that are effective immediately. So that named agent doesn't need to get a physician's certification of incapacity before they can start transacting on your financial accounts, because the person that you name in the document should be someone that you trust, right? And if you can't trust the person to make the right decisions while you're not incapacitated, then you probably shouldn't name that person to have that power and make decisions for you when you are incapacitated, if that makes sense. The alternative would be to make it effective upon physician certification, which is a springing, document. So just a couple of things there. Again, you're going to get a copy of this in the recording after our presentation. Alaina, can you introduce our audience to wills and trusts as our next topic?
Yeah, of course. Whoops, I got too excited. I can. Thank you, Dom, for that information about the different powers of attorney. I think it's really important for everyone to realize that those documents come into effect and are typically effective while you are still living. But then the other big part of any estate plan is going to be that last will and testament, which comes into effect once you have passed away. And you said this earlier, but I think many people are familiar with this term. The will is usually the core part of your estate plan because it details what happens to your assets at your death. So, what is a will? A will is simply a legal document that expresses a person's wishes as to how their property is to be distributed after their death and names a person to manage the property until the final distribution. A person who creates a will is called a testator. You may also hear the feminine version sometimes, which is a testatrix. It's a fun word to say. And like I said, unlike those powers of attorney that come into effect while you're still living, your will only comes into effect once you've passed away. So let me reiterate that one more time. Your will only comes into effect once you are no longer with us. And what this means is that a will can be changed up until your death, so long as you have your testamentary capacity. Testamentary capacity means you have the mental and legal ability to create a valid will. If you do not have testamentary capacity, because of some sort of mental decline or some other issue that may be affecting you, you cannot change or create a will. This definition becomes very important when someone starts dealing with physical and mental health issues that affect their ability to understand, such as Alzheimer's and dementia. So how do you create a will? State law, whatever state you're in, controls what makes a will valid. So the requirements to make a will in Georgia may be different than the requirements to make a will in Illinois. There may be certain requirements as to how many witnesses you need, whether you need a notary, whether it can be digitally signed. That's a new thing we've been seeing. Some states allow a handwritten will, called a holographic will, to be valid without witnesses, while other states do not recognize that sort of will. So it's very important to understand what makes a valid will in your state, which is why it's usually best to consult with a local attorney to see what your options are. So what assets are going to pass under your will? That's a really big planning point. So please note that your will only controls certain assets. And those are going to be assets that are in your name at the time of your death that you do not own with a joint tenant with rights of survivorship, and that do not have a beneficiary designation or a POD or TOD, which stands for payable or transfer on death designation. A bank account or a brokerage account in your name alone, yes, that will typically pass under your will. A 401k or an IRA that has your spouse listed as a beneficiary, no, that will pass to your spouse as that designated beneficiary. A piece of real estate that you own with your siblings as joint tenants with rights of survivorship, again, that real estate will pass to your siblings automatically. And I'm going to show you a graph in a minute that goes into more details about how assets pass. So the downside of passing assets under a will is that usually the will must go through the probate process. Probate is the act of proving a will. And again, we're going to go into more details about this in a minute, that probate process. So who then are the beneficiaries of the will? Generally, you can benefit anyone you like under your will. In some states, it can be harder to disinherit a spouse or minor children. So make sure you talk to your legal counsel about that. But for most people, your will can leave your assets to anyone you like. Many wills will separate distributions of personal property, which is your stuff, your jewelry, your cars, your silverware, versus the bulk of your estate, the residue. So everything else that your will controls. When I was in private practice, a lot of clients struggled with what to do with their stuff because nowadays a lot of people don't want their parents' fine china or their big furniture. The kids are already set and established in life with their own stuff. So that was a really big struggle for a lot of clients is what do I do with all of this now because no one in my family wants it. A lot of states allow for your property, that personal property, to be distributed via a separate memorandum. So if you want your china to go to your sister and some jewelry to go to your grandkids, but everything else to your spouse generally, you can specify that outside of the will itself. That makes it a lot easier to distribute that personal property without having to redo your will every time you change your mind about who is getting your coin collection or your cars. For the residue, though, you can make specific gifts, percentage gifts, or formula gifts. You could say, for example, I leave 10% of my estate to my church and the balance to my kids. You could also say something like, I leave $50,000 to each of my nieces and nephews and the balance to my siblings. You could do any combination of these two. You know, the world, or the will in this case, is your oyster when it comes to deciding who is going to receive your assets. You can also decide to leave everything outright to the beneficiary of your choosing or in trust. The most basic will says, I leave everything outright to my spouse, and if my spouse doesn't survive me, I leave everything outright to my kids. More complicated wills will create irrevocable trusts for spouses or other descendants. These trusts can provide substantial asset protection and or tax planning opportunities for the benefit of your beneficiaries. I think trusts have gotten a bad reputation of the testator trying to control assets from the grave. However, recent changes to many states' trust laws have made trusts much more attractive and lenient, with the trustee having a lot of flexibility over decision making. So the trusts that are created under your will are called testamentary trusts because they're created under your will, your last will and testament. Another common vehicle that we see in estate planning is called a revocable living trust. So that revocable living trust, or RLT for short, is a trust that can be changed by the grantor, which is the person who creates the trust during their lifetime. One common misconception I see a lot is people confusing the living trust with the living will, which Dom just talked about. So a living will is a healthcare document that states how a person wants to be treated medically if they are unable to make their own decisions due to a terminal illness or permanent unconsciousness. The living trust that I'm talking about here, this is a tool that we use to avoid probate and plan for incapacity. So those are very different. With the trust, the grantor names an initial trustee and beneficiary who are usually the grantor themselves. So I would say, I, Alaina Davalos, have created the Alaina Davalos Revocable Living Trust, and I am the primary beneficiary of that trust. Any assets held in that trust are to be used for my benefit. Sometimes we will see a spouse included as a co-trustee or a permissible beneficiary. So I could say me and my husband, we are to be co-trustees of the Alaina Davalos Trust. The revocable trust usually then covers 3 scenarios. The first scenario is while the grantor is alive. The second is when the grantor passes away but is survived by a spouse. And third, at the surviving spouse's death, or if the spouse did not survive the grantor, when it comes time for the kids to inherit. Those second and third scenarios, where a spouse or descendants inherit from the grantor, those are typically going to be the exact same provisions as would have been in a will. A revocable trust is most commonly used as a will substitute in order to avoid probate. Because unlike a human, a trust doesn't die. So the assets that it holds do not need to go through probate to pass to someone else. You can have the same asset protection, create the same testamentary trust, do anything you could do under a will with an RLT, but have it be a lot easier process for your beneficiaries. So why doesn't everyone do this? Why isn't, it's a very common thing. You need a revocable trust, you, your neighbors, your friends, everyone has one. First, because they can be more expensive to establish. A revocable trust is typically a longer document, and it usually has an accompanying pour-over will with it as well. Because just in case you do not do your homework, which I'm going to talk about in a second, and transfer all of your assets to that trust, you may still have probate assets that need to go through that formal process. So you have a will that says, okay, I leave everything to the trustee of my revocable trust. And that allows your assets to pass cohesively via the terms of that trust. The other big problem that dissuades a lot of people from using a revocable trust is that it needs to be funded during the lifetime of the grantor to be effective. That means assets need to be moved into the name of the trust. So if you've got real estate, that real estate needs to be deeded to the trust. If you've got a brokerage, you need to change the ownership of that account to the trust or add the trust as a transfer on death beneficiary. This can be a lot of homework for some people that aren't really up to the challenge. So I will say, the good thing about working with a financial advisor or RIA such as Savant is that we can help, move those assets into the trust, make sure that that plan is really being taken advantage of. One quick thing to note is about taxes. So during the grantor's lifetime, the revocable trust uses the grantor's social security number typically. So creating and funding that trust has no impact on the grantor's income or estate taxes. At the grantor's death, an irrevocable administrative trust may be established that needs to file for an EIN, which is an entity identification number, like a trust social security number, with the IRS. If any sort of beneficiary trust is established, either for a spouse or descendants, they would also need a new EIN to file their own taxes, but that's only after the grantor's death. So whether you've got a will or a revocable living trust, it will name your people, called your fiduciaries. The primary person in a will is going to be the executor. An executor is a person or institution appointed by a testator to carry out the terms of the will. So the person who's going to be responsible for transferring assets from the testator's name to the final beneficiary who's named under the will. If you have minor children, your will may create a trust for their benefit, and in that case, the will also name a trustee, who is a person that holds and administers property for the benefit of the beneficiary under the terms of the trust. Again, also, if you have minor children, your will name a legal guardian for them. So who is the person who's going to look after them and be legally responsible for someone that until they turn of age and can manage their own affairs? In a revocable trust, the trust agreement will also name a successor trustee to the grantor. So the initial trustee, like I said, is typically the grantor themselves. Then they would name their spouse, for example, and then their oldest child. A lot of times I would have clients that would want to name all of their children, usually in age order, so that none of them felt unappreciated. The appointment of a successor trustee, having those people in line, this can also help with incapacity planning, because that successor trustee is going to be able to immediately step into the grantor's shoes while they're still living and access the trust assets and manage them on behalf of the grantor if the grantor loses their mental capacity. Family members wouldn't have to go to court to be appointed as a guardian or conservator because they would already have legal access to the assets and could make decisions on the grantor's behalf. In choosing your people for these positions, you can name 1, 2, 3 people. Legally, you can usually do as many as you like, but logistically, it gets harder the more people that you have named. If you do name more than one person in these roles, let's say you want co-executors or co-trustees, you'll need to decide if those people need to act jointly or if they can each act on their own individually. And another thing to remember too is that you can name the same person in each role. You could have your spouse named as your primary executor, successor trustee, healthcare agent. Then you could have someone after that, let's say a sibling. You would name them as your contingent executor, your second trustee, your second agent in the event your spouse couldn't act for some reason. And it's very natural, especially to have your financial power of attorney be the same as your executor or trustee. All of those roles have to do with managing your money, managing your assets, but there's no requirement to do so. A lot of times, I've seen clients really struggle with choosing their people if there's not an obvious choice, such as a parent, a sibling, or a close friend. And it can lead many people to put off doing their estate planning. If you or someone you know is in that situation, my best advice, especially if you have young children, is that having a will that names someone is better than nothing. Because if something happens to you or your spouse unexpectedly, the last thing you would want to have happen is for either the court to decide who has guardianship over your children and institute a conservatorship to manage their inheritance. This can be very stressful and very expensive procedure for your family. So please, especially if you have minor children, get a will done that takes care of them. And if
Alaina,
you can't think of a person, if there's no individual you think would be good at these roles, there are corporate fiduciaries who are available to act and take care of these things. Here at Savant, we work with Savant Private Trust, which operates via National Trust Company. And that allows us as the financial managers to work hand in hand with our clients that have established these trusts. And we typically have Savant Private Trust named after a series of individuals.
Alaina, I was just going to add, 'cause I think you brought up an excellent point about a roadblock to actually getting these documents executed, figuring out who those important people, the fiduciaries, are going to be. It's probably easier in some cases if you're struggling to come up with a list of people that you wouldn't want to be making decisions or have custody for your children. So as a tip, maybe start there, right? Visualize those people and then pick whomever makes sense in the short term, for the next 3 to 5 years, because you can always come back and change these documents. As Alaina had said, they're revocable during your lifetime.
And the one other thing that I would mention is if you're struggling with who to name, you do not need to name the most financially savvy person. What you really need is someone who knows when to ask for help. Someone that knows, hey, I need to go to the attorney. Hey, I need help with my CPA. That's who is really going to make for a good fiduciary. So with all of these people and all of these documents, how does property actually pass? And I have the most lawyer answer for that, which is it depends. So we talked a lot about the difference between a will and a revocable living trust. However, those documents only control a portion of assets. And I alluded to this earlier, that assets pass differently depending on how they're held. For example, assets that you gift during your lifetime, they don't need to go to probate. They don't have any part of your estate during your life because, you guessed it, you gifted them away and you no longer have control over them. Now, it's crazy how that works, right? So lifetime gifting, though, can impact your federal estate tax exemption amount, which controls how much your estate owes in estate taxes at your death. Generally, if you make any gift above $19,000 this year to any one person, you should consult with your attorney or CPA on how that impacts your estate tax exposure. One thing to note is that that $19,000 number is controlled by Congress and is adjusted for inflation, so it may change every year. Generally, if you gift over that amount if you're single or double that amount if you're married, you may need to file a 709 gift tax return. And depending on what you're gifting, that can either be very easy or very complicated. So make sure to consult your advisors. The other main way that assets pass is, of course, at your death. And a very common way that assets pass is going to be via beneficiary designation. So many qualified accounts, including 401ks and IRAs and typically life insurance, those pass via beneficiary designation, where you've notified the custodian of those accounts that at your death, those accounts will automatically pass to your beneficiary. Typically, they would need to provide your death certificate. They say, hey, you actually are gone, and those assets are mine now. Anytime that you are updating your estate plan, you need to make sure that you update your beneficiary designations accordingly. They go hand in hand, so please do not forget that. Same thing with property that is held jointly. Property that is held as joint tenants with rights of survivorship passes automatically to the surviving joint owner. Property that is held as tenants in common does not. If you're trying to avoid probate by having all assets pass via joint ownership, a tenancy in common can ruin that plan and cause your will to have to go through probate unexpectedly. One other way that assets pass is going to be with that TOD, transfer on death, or POD, payable on death, to accounts that you want them to go automatically to someone else. So a TOD is typically added to a brokerage account, and a POD is typically added to a bank checking or savings account. Your revocable living trust will only control those assets that have been moved into the trust during your lifetime. If you deed your home to the name of your trust, your successor trustee would be able to immediately sell your house, for example, or if you have transferred ownership of a brokerage account to your trust, your successor trustee will have that automatic access. And last, you've got your last will and testament. Like I mentioned earlier, only controls those assets that are in your name alone. They have no joint ownership, they have no beneficiary designation, they have no connection to anyone else. So aligning all of these different pieces is very important. I hope you guys like this chart here, because this is what Dom and I spend most of our days doing when we're presenting to clients, which is making these charts and showing them so that they can see exactly how their plan is going to work at their death and see if there's anything that needs to be done before that occurs. We look at jointly held assets, estate planning documents, assets passing via beneficiary, assets that are outside of a client's taxable estate, all of those things. We want to make sure that our client's estate, which they've usually worked their whole lives for, is going to pass as seamlessly as it can to their final beneficiaries. So on this chart here, you'll see that we have an example client who has a joint revocable trust that creates tax-efficient spousal trusts for the survivor of them, and then creates lifetime descendants trust for their kids and other descendants. This is a bit more complicated of a plan, but this is what worked best for these specific example clients. And I know Dom and I have done this webinar before, and a lot of people had more questions about what these entailed, about spousal trusts, about the descendants trusts, and the value of this, going into a bit more detail. So Dom and I actually have another estate planning webinar where we covered this in more detail. And again, you can find that on our Savant YouTube channel. So let's say now what? Let's say you're like these clients, you've got your documents in place. What do you do now? Dom, can you give us some pointers?
Absolutely. And that's really the next step. So hopefully everybody has a better idea of the core building blocks to an estate plan. And don't worry, estate planning is a process, right? And you approach it one step at a time. But once you have your documents in place, you've aligned your beneficiary designations, retitled your assets. Sometimes it's important to focus on communicating your plan and really just getting organized for the future. So when you think about estate planning, again, as a whole, it's really a balancing act of keeping things efficient, simple, while also creating protections while minimizing costs and expenses. And I really like that last point about preserving family harmony. And ambiguity is the enemy of estate planners. The more that you can clarify your intentions, have a well-written, well-implemented estate plan, hopefully that will minimize any family conflict, especially when things are very smooth post-death, which is why it's important to have good estate planning documents and good advice. So on the next slide, I want to mention that Savant has created a tool that you can use as part of your overall estate plan to help fill in the gap, so to speak, that your legal documents themselves don't address. So after our webinar today, along with the recording and a glossary of key terms with definitions that we've used today, everyone will also receive a copy of Savant's Estate and Trust Administrator's Guide. And this Estate and Trust Administrator's Guide allows you to capture important information like who to contact when you and your spouse pass away, or just you if you're not married. Who are your financial professionals that you work with? What are their phone numbers, email addresses, other contact information, your financial advisor, your attorney, your accountant, your insurance agent, right? All of the financial professionals that you engage with will have a role to play after you pass away. And this isn't always known to your executor or trustee. Where are important documents located, right? A list of your assets. Being organized and having everything well documented is one of the greatest gifts that you can give to your loved ones. Because quite frankly, being an executor or a trustee is hard work. You're discovering what that person owned. You're filing income tax returns. You're providing accountings and other information to the beneficiary. You might be working with an attorney through the court process if there's probate exposure, which Alaina is going to talk about in a little bit. So just getting organized, documenting all of your asset information, very, very important. Create a trail of breadcrumbs is really the takeaway, right? That will just make the estate administration process much, much easier. Alaina spoke earlier about choosing fiduciaries, right? The people you name in your documents, very key. So I think we got a good overview there. We're going to bring back our friend, our diagram, because we like to show this again here because estate planning can be really complicated, right? Especially if you don't deal with it every day. And once you create your documents, sign them and execute them, the job isn't over. As Alaina mentioned before, assets can pass in different ways. And it's important to then follow up with your attorney, financial advisor, insurance agent, so you can update your beneficiary designations, the titling of your assets as well. Because if you go through the hard work and expense and thoughtfulness of creating a trust, but you don't fund your trust, and now you're exposing your assets to probate, then you've taken an A+ plan and really gotten a C- grade because of poor execution. So just wanted to reiterate that point. And it's important to review your assets from time to time as you acquire assets, right? You might have to then title those new acquired assets to your trust. So it's a constant exercise, but your financial advisor and attorney are here to help. Right. And Alaina, can you give us an overview of the probate process, please?
Of course, because probate is such a fun experience for everyone that goes through it. I can't go into a lot of detail because probate is very state specific and I don't want to get sued, but I can give you a good 30,000-foot view. So I think most people's knowledge about the executor and the probate process, that generally comes from TV. And on TV, there's usually a gathering of the family in the lawyer's office. Everyone's waiting with bated breath to see what they're going to inherit. The executor is announced, and it's not who the family expected. It's all very dramatic, right? In reality, it's usually not a spectacular event. So the person who passes away is called a decedent. The decedent either had a last will and testament or they didn't. If they had a will, it most likely named someone as the executor. Hopefully that person is still living and has capacity. The will may also refer to that person as a personal representative or an administrator. For our talk today, I'm just going to use the term executor. So for the family to first find the will, it's usually with the decedent's personal effects in a safety deposit box, or it's with a drafting attorney. Most wills today are written in modern English and are relatively easy to understand. Sometimes there's a lot of language in the document. I myself was known to draft a 50-page will on occasion. But identifying the nominated executor is usually pretty easy. The executor, though, is not automatically in power. Let me repeat that. Just because someone is named in the will as the executor does not mean that they immediately have the authority to act on behalf of the decedent's estate. Why? Well, for starters, the decedent may not have a probate estate, meaning that there are no assets that the will controls. If the decedent only had an IRA with a beneficiary designation and a home held with joint tenants with rights of survivorship with the spouse, then there is no probate to do there. The will only has authority over assets in the decedent's name alone. The will does not control those jointly held assets or any asset with a beneficiary designation. So let's say, though, that the decedent did have at least one of those probate assets. Let's say they also had a will. How does the executor gain their legal power? As I mentioned, this area of law is very state specific. So each state has their own rules and regulations about going through the probate process. The probate process is defined by the American Bar Association simply as the formal legal process that gives recognition to a will and appoints the executor or personal representative who will administer the estate and distribute assets to the intended beneficiaries. Generally, the decedent's heirs at law and the beneficiaries under the will be notified and given an opportunity to object. If there are no objections, everyone agrees, the court will issue the executor the legal documents authorizing them to act. The court may also sometimes require an executor to post bond based on the projected value of the assets in the estate. They may need to file an inventory, provide annual accountings. It really depends on the court and the state law. But once the executor has those legal documents, you can see here on the screen the usual process. The executor has filed the will with the court. They've got to administer the estate now. They collect the bank accounts, get appraisals on real estate or list it, notify business partners of death. It really depends on the assets. The executor also must notify any of the decedent's creditors of the decedent's death and pay final expenses. This can include funeral bills, medical expenses, costs of administration, such as legal and CPA fees, and any final taxes. The executor is legally responsible for filing any tax returns that are due. So always keep that in mind if you are named as an executor. Once that's all been completed, the executor can formally close the estate. And closing the estate generally releases the executor from any further liability related to their role. They're hanging up their hat, as the saying goes, I'm done. Don't spend your inheritance all at once. While this can sound relatively simple, there are also aspects of being an executor that make it an undesirable job. And, as Dom mentioned, that family conflict, there's a reason why we really promote family harmony when dealing with a probate, because family conflict can make this a very difficult job. Other things like taxes and unusual assets like business interests, oil and mineral rights, out-of-state real estate, those can cause problems for executor. But generally with good planning, the executor can be a short-term role that keeps the family harmony and sufficiently distributes the decedent's assets. One positive side, though, of being an executor is that you can get paid. Either the will or state law dictates what the executor can take as their fee. So if you are, make sure you're either, if you're creating your own will or if you're acting as an executor, make sure you're aware of what those executor fees are. If you do have a revocable trust, you'll have a trustee instead of or in addition to an executor. And the trustee's role is very similar to the executor's. The trustee is responsible for administering the trust and collecting the trust assets, whether that's from the probate estate or assets that named the trust as a beneficiary. The trustee then pays any taxes, debts, or administration fees that weren't paid by the executor. Sometimes a revocable living trust will not end, however. Instead, it will morph into an irrevocable trust. And in the graphic you see on the screen here, we've got a revocable living trust that changes into a trust for the survivor, which in this case means the surviving spouse. At that surviving spouse's death, the trust changes again into subtrusts for the children. Those children's subtrusts are generally irrevocable, and if that is the case, if the trust fund is not simply paid out to the trust beneficiaries, then the trustee has additional duty. They'll continue to manage and invest the trust assets on behalf of the beneficiaries, approve any distribution requests, and file any annual trust income tax returns. They'll also make any mandatory distributions that the trust dictates, such as 1/3 of the trust fund outright to the beneficiary when they reach age 25, and the balance outright at 30. Whatever the trust says, the trustee must do. So as opposed to being an executor, being the trustee can be a long-term duty. So make sure you're aware of that if you're nominated as a trustee or when you're nominating your own successor trustee. And it's important to differentiate between the roles of executor and trustee because they're controlled by different documents. The trustee is subject to the terms of the trust agreement, and the executor is subject to the rules of the court and the terms of the will. Dom, can you give us a quick overview of taxes? Everyone's favorite subject?
Sure. This is a great topic to end with because there's been some updates that you may be aware of if you've been following the news. But a common question that we receive is, will my family have to pay taxes on their inheritance after I pass away? And on the next slide, we have an update for you. There's two types of taxes that typically come into play. The one we're focusing on here is estate tax, which is the tax on the transfer of wealth to your loved ones. And under the Tax Cuts and Jobs Act that was passed at the end of 2017, the estate tax exemption per individual was doubled from $5 million to $10 million, inflation adjusted every year. And up until the 4th of July, the exemption was set to sunset or expire at the end of this year, 2025. But under the One Big Beautiful Bill Act, the federal exemption per person is now $15 million. And that's a permanent adjustment with inflation adjustments every year and increases. So the big takeaway there is that many families are just simply not going to have a federal estate tax problem. Now, depending on the state that you live in, on our next slide, we have a nice map. The state that you live in may impose estate or inheritance taxes, and the thresholds, the exemptions for what is exempt from estate tax is often much lower than the federal exemption. For example, Illinois, where our company is headquartered, has a $4 million per person estate tax exemption. So don't forget about state estate tax planning. Your attorney and advisor can help you come up with the right structure in your plan to avoid unintended estate tax exposure at your death is the big takeaway there. Other taxes that often come into play are income taxes. So in our next slide, we have a reference to a couple of tax forms that have to be filed. But getting back to that question, does my family have to pay tax on the inheritance they receive? From an estate tax standpoint, probably not federally, maybe, depending on the size of your estate. If you're ultra high net worth, it could be an issue, and there can be planning done to minimize that estate tax exposure. But from an income tax standpoint, it's really based on the type of assets that you leave to your beneficiaries, like 401k, retirement accounts, IRAs. Those accounts are subject to income tax when money is withdrawn. Investment accounts, brokerage account, after-tax trust account assets are subject to capital gains taxes. But when you pass away, those capital gains essentially get reset to zero because the cost basis gets stepped up at your death. So just an introduction to those two concepts, but I want to clarify the difference between estate tax and income tax. Okay. Something that's often overlooked, and this gets into the duties of an executor or trustee, is filing important income or estate tax forms with the IRS or the state revenue department, depending on what state you live in. So when you pass away, your estate might generate income from the date of your death until your assets are distributed to your loved ones. And as Alaina mentioned, right, there's an EIN number that's gotten for your probate estate as an entity. Your executor might have to file an estate income tax return to report that income from death until your estate is closed. So don't forget about that. If you have a trust that becomes irrevocable, your trustee is often required to file a trust income tax return. Form 1041 is the number of that form. Every year until for as long as that trust is in existence. And as Alaina mentioned, trust can continue for a very long time period, depending on whether there's continuing trusts that benefit your children, other loved ones, intended beneficiaries. That last reference was to the estate tax filing, Form 706. That would need to be filed 9 months after death if you have estate tax exposure. And I think you should have a couple minutes for questions, Alaina.
Yeah, for sure. So we won't have time today to address everyone's questions. So if you'd like to discuss your unique situation, please schedule a complimentary 15-minute call by clicking the link in the chat to schedule that time that works for you. We appreciate everyone being here today with us, and we are going to address a couple of the questions that we did receive. So I think I'll take this first one, Dom. Do I need a will if I have a trust? And so I touched on this briefly. If you have that revocable living trust, you typically also have what's called a pour over will. So in the event you do have any assets that will go through your probate estate, assets that were in your name, you want everything to pass cohesively under your living trust. And so you'll get this little pour over will, it's anywhere from 3 to 15 pages that just says, hey, if I have these probate assets, give them to my trustee. That's typically what we see. So another question here. I'm named as the executor in my parents' will. Do I have to do it? Dom, would you like to take that one?
That's a great question. And as Alaina mentioned, because you're nominated in the document doesn't necessarily mean that you need to act. For example, if there's no probate exposure and you're named as the executor, there's really not a whole lot for you to do if everything is being administered by the trustee of the trust or passing by beneficiary. And also, you always have the right to decline or resign from these appointments if you're unable to act because it's just that doesn't make sense for you given your personal circumstances.
Or if you just don't want to.
Or if you don't want to, right? That's it's a lot of work. Yeah.
You might be haunted, but you don't have to.
That's right. That's right.
So last question we're going to take, what is the cost of setting up an estate plan? So again, with my lawyerly answer, it really depends. It depends on how much complexity is going into your documents. It depends on if you have a will-based plan or a trust-based plan. It depends on the local costs that your attorneys will work with, or if you're doing something online, doing it yourself. It's all over the board. But generally, I will say this is a pay it now or a pay it later. Either you can cover those costs up front and create a seamless plan for your family, or you can leave them with something a bit messier, which will be a bit more expensive down the road at your death.
It could be a lot more expensive depending on how big of a mess you leave. So it's a good investment.
Could be a big mess.
Could be a big mess. Thanks everyone for your time today. We appreciate it. We'll see you next time.
Thank y'all so much. Bye.
If you enjoyed this webinar, visit savantwealth.com/guides and download our complimentary guidebooks, checklists, and other useful financial resources.